Hey, good morning, Lalians. It is Tuesday. No, it's not. It's Wednesday. Give a guy a Monday off and everything is recalibrated. But I'll certainly wake up Saturday wanting it to be Saturday and not walking in here on Friday. So in any case, good morning, everybody. Good morning, Michael. How are you?
I'm well. Good morning, Norm. You sound so crispy and beautiful. Goodness gracious.
I'm married, young man. Thank you.
You
Crispy and
got a voice
beautiful.
for radio. I miss
A
those
voice for-
WICC days because they had the whole. But we've got you sounding like that now, I think.
Well, it's taken a long time to get this tech stuff there, and I missed the WICC days too. Last week when my wife and I headed up to the Cape, thinking, well, I guess I could have a 6-month suspension. I submitted an application to WOMR in Providence or Provincetown rather. They have a spot open every Saturday from 9 to 11. And I said, I can bring controversy. And I've associated along the right for a long time and can talk to your listeners because Provincetown is a decidedly left-leaning community about what the world looks like from the perspective of the Proud Boys, Alex Jones, and others. Haven't heard back yet, but I am looking for a berth in radio. I love radio. I love this podcasting. I love talking to you folks, even if sometimes those conversations are a little wonky and tense as they were between Mike and I yesterday. We're not on our way to family court, folks. We're like the United States. We're like every other couple in the United States. It's Memorial Day. It's the pause that refreshes before the 2024 election. We will go and have a good time this summer and relax. And then come Labor Day, all eyes will be on Washington and the races around the country to see who will next become the president of the United States and to see, well, what will become of the United States. And that is our central preoccupation here at Law and Legitimacy. It always was, always has been, always shall be. We can't guarantee you that we have a destination in mind any more than anyone can forecast what the country will look like in 2025. But we can give you an honest perspective on how it looks from where we sit now, and we can take your viewpoints and reflect them into a discussion that we hope enriches your lives. We promised today to do some questions and answers, an open mic day, and we will. But first, I wanted to just do a little bit of low-hanging fruit on a couple observations on the Trump trial, the hush money trial in Washington, the trial being presided over by Judge Juan Merchan. I saw some outrage yesterday online in the little bit of time I spent surfing.
What? You found outrage online?
Yeah, I know. What was I doing? Can you find anything other than outrage unless you're here on Law and Legitimacy? But, the claim was that there was some constitutional problem. Oh, get him off the screen, please. The problem is that the notion was that there was some constitutional problem with the fact that Donald Trump's team didn't get to give the last closing argument. And I thought, seriously, how does that become a constitutional problem? I don't know how each state allocates closing arguments, but I thought I would give to you listeners a perspective of what closing arguments are and how some states manage them. My primary practice area is in Connecticut, and as it turns out, yesterday was opening.
Norm, just as some additional fodder for you, may we also revisit the concept of reasonable doubt?
Absolutely.
Jury instructions are likely to be given today, and that is the legal standard to which that jury will be deliberating.
Yeah, we will talk about legal standards and the quantum of proof necessary. So, but a closing argument is an opportunity for lawyers on each side to tell the jurors what they think the evidence shows. And they're not supposed to say, I think this, because the lawyers' views don't really matter. Lawyers aren't supposed to inject themselves into the case. Certainly prosecutors aren't. But you are to comment on what you think the evidence shows. And so you'll say, you've seen these documents. You've heard the testimony. The prosecution might say, it's clear that Donald Trump from the evidence was trying to hide the true source of these payments. They weren't retainers to Michael Cohen for services rendered. What they were payments to Stormy to keep her mouth shut for some service that she rendered that Donald didn't want the nation to talk about, because he thought it would undermine his presidential chances. And then the prosecution, or then the defense will stand up and say, this wasn't it at all. There was nothing unlawful about the consensual relationship that Mr. Trump had with Stormy Daniels. There was nothing unlawful about the payments that he made to her, the hush money payments. There was nothing unlawful about using Michael Cohen to broker those payments. And by the way, Michael Cohen is an inveterate liar, and you ought not to believe a word he has to say. And so each side makes their pitch. It's the state, the people, that have the burden of proof. And so in Connecticut, for example, each side is allocated, unless there is permission from the court otherwise, 1 hour for closing argument. The state gives the first closing argument, and then it gives the last closing argument, but it can use no more than an hour. The defense talks in the middle, as it were, and can use only an hour. And when I was a lawyer, I'm thinking, oh, it's unfair. The state gets to talk twice. It's unfair that that we don't get the last word. But the reasoning is it's the state that has the burden of proof. So it opens with what it has to say. The defense rebuts, and then the state rebuts the defendant's rebuttal with its last word. That's all. And so how this time gets allocated doesn't raise constitutional issues to me. And my eyes rolled when I looked at the controversy. There was an interesting rule that Mershon ruling made during closing arguments yesterday that did get my back up a little bit. And as one of Trump's lawyers was arguing that you cannot put Donald Trump in jail on the testimony of an inveterate liar like Michael Cohen, the prosecution objected and said you cannot bring sentencing consequences to the jury, and Mershon sustained that objection. And this is one of the real fault lines in criminal defense. Jurors are supposed to find facts, and judges impose consequences. And the result is that we treat juries like assembly line workers who are not responsible for the consequences of what they build. We tell jurors, you will only find whether Mr. Trump is guilty or not of the offense charged. If he is, don't worry about what happens. Put that out of your mind. And I think that's a false note. I think that the consequences of a criminal conviction are enormous, both financially and socially, especially in the case of a presidential candidate. And jurors ought not to be treated like infants. They should be informed of the sentencing consequences. Some states have permit jurors to comment on sentencing. Some states permit jurors to give advisory opinions on sentencings. I believe some states permit jurors to impose the sentence itself, although I'm less certain about that. So there are a lot of ways to do it. In terms, and in New York takes the childlike approach. Jurors simply say guilty or not, and then the judge imposes consequences. That's an insult to jurors everywhere, and the system should be reformed. What is reasonable doubt? So there are a number of legal standards. The legal that jurors are asked to apply and fact finders are asked to apply in court proceedings, and they range from proof beyond a reasonable doubt, to clear and convincing evidence, to a preponderance of the evidence, to an articulable suspicion, or to probable cause, to articulable suspicion. And these 5 standards do almost all of the work in the American criminal and civil justice system. Proof beyond a reasonable doubt, the judge will tell people, is not absolute certainty. It's something less than absolute certainty. The standard charge in Connecticut on proof beyond a reasonable doubt is it's the sort of doubt that would cause a reasonable man and woman to hesitate before acting on a matter of importance. It's a real doubt. It's an honest doubt. It's the sort of doubt that flows from the evidence or lack of evidence. It's not a doubt arising from sympathy for one of the parties or antipathy toward another. It's the sort of doubt that ordinary people heed in matters of importance in their general life. And that's a more robust statement of reasonable doubt. And it's pretty accurate. I've heard it more times than I can recall. The federal standard is, abiding certainty, and I don't know whether New York comes closer to the federal standard or the Connecticut standard. The abiding certainty language comes close to making reasonable doubt sound like more than it is. But it's also not really a standard. It's a state of mind about a standard. I've taken this issue up to the Connecticut Supreme Court because we have a rogue judge here named Judge John Blue who gives the federal standard, and I've tried to say he's charging a state of mind, not a standard, and the federal courts disagree with that. Jules asks, will the court accept a majority or unanimous verdict? It has to be unanimous. So what will happen is if all 12 jurors agree that there is doubt, the verdict will be not guilty. If all 12 jurors agree the case has been proven beyond a reasonable doubt, then that's guilty. If there's a disagreement and the jurors can't agree, then that is the potential for a mistrial, no verdict. In such cases, jurors are brought into a courtroom and judges give them a charge that says something like the following: I understand that there is a disagreement and that there is not unanimity as to the verdict. I'm asking each of you to reconsider your views in light of the conscientiously held opinions of others, and to resume your deliberations. This out of respect for one another and out of respect for all the hard work of a trial. When I'm picking juries in Connecticut or elsewhere, I always remind jurors that no one alive, not the judge, not the foreperson, no person ever to be born on this planet has a right to ask a juror ever to change their vote simply for the sake of a unanimous verdict. What I'll tell the jurors is that my client has been accused by the state of a crime. He doesn't trust the state to conclude whether he committed it. They made their choice with the accusations. He's placed his future in your hands, and you stand between the state and the individual. And we've asked for 12 strong and independent minds to evaluate the accuser here. You're not to sit in judgment over Donald Trump. You're to sit in judgment over the people of New York. It picked this fight. It picked the charges. It decided how to wage it. Judge for yourself. Have they proven this case beyond a reasonable doubt? Because if they have not, it is your sworn duty to return a verdict if not guilty. So don't be seduced for a moment here that you're sitting in judgment over a man who was once president. You're not. You're sitting in judgment over the current and present sovereign who has the power, the ability, and the right to accuse any one of us of the crime of its choice. And under our constitutional system, we, the people, get to sit in judgment of that decision. That's your role today.
I think that's powerful. I think that's powerful. One thing about the unanimity of the necessary verdict and reasonable doubt, there's a question the question remains as to what the felonious conduct is. What is, the crimes being charged? There's an article on reason.com this morning by a gentleman named Jacob Sullum. I'm going to put it on, just a quick blurb of that on the screen here and quote it. It says, quote, there is a glaring mismatch between the charges against Trump and what prosecutors describe as the essence of his crime, which is not a crime at all, since they cannot charge him with, quote, election fraud merely because he tried to hide embarrassing information. They have instead built a convoluted case that relies on interacting statutes and debatable assumptions about Trump's knowledge and intent. In the end, the jury may well buy it. Steinglass, which is prosecutor, quote, knows that many of these jurors who have promised to be fair and unbiased may hold opinions about Trump that they are not supposed to take into account at this trial, end quote. Times reporter Jonah Brumich writes, quote, but he is linking the case against Trump to what his political opponents say about him more generally and what he is trying to play on the jurors' potential political sympathies while still talking about the evidence that entered the courtroom. And he goes on to say that it may or may not work out for him, that being Steinglass. I think that's an interesting characterization of what's going on. I think it captures the essence of this case and the controversy, Norm. Judge Merchan is obviously a lightning rod of controversy and frustration. I think there's some merit to that. We've talked about it before. But I also think that from where I'm sitting, and what I've expressed before is that I'm not persuaded that the non-disclosure agreement is unlawful or unlawful conduct. And I'm
No, I
not
think it's
sure,
right.
and I'm not sure that a statute that is being impressed upon the jurors by the prosecution for the first time in this manner is the time to be examining whether Trump even knew whether the NDA was legal or not, right?
I might be missing something, Mike. I thought that the prosecution didn't depend on the NDA being illegal. That what was
They haven't
the claim
clearly
is
articulated. Go ahead.
no.
Sorry.
I think the claim. I think the prosecution is agnostic as to that claim. I think the claim is that characterizing the payment as legal fees to Cohen is the fraud, and that is a misdemeanor. I think that the attempt to make it a felony would require the people to prove that this was done for purposes of election
Yeah,
interference, but they've
unlawful.
offered no such proof.
No,
They've offered no such
for
proof.
unlawful means, the quote unlawful means, which is what implicates the NDA. Right?
Right.
And so that's what I mean when we really get at the essence of this case. It's not even clear what the felonious conduct is or whether the prosecution has even made a clear case as to what Trump's state of mind would have needed to be in order to even rise to the level of that felonious conduct. I don't know. So for that reason, I think that these jury instructions are going to be incredibly important. The reporting coming out of the courtroom, depending on from which lens you're looking, is outrageous on both sides, right? Either, Trump's legal defense team is doing outrageous things. Norm, you mentioned a note from a friend earlier that where the judge actually had to do some curative instructions for the jury during the defense closing. Do you remember that?
I do, but let's talk about curative instructions. I'm in trial in a murder case right now, and it's well observed. There were 30 or 40 people in the courtroom yesterday, and some of them came up to me and said, "How come when the judge sustains an objection, you turn around and ask the same question all over again?" And I said, "Because I'm worried that the jury didn't hear it the first time." And he said, "But aren't you not supposed to do that?" And I said, "Well, that's an argument, I mean, an advocate's job is to frame the case in the best terms possible for his client. I don't think that Trump's lawyers did anything outrageous at all by reminding jurors that the potential consequences of a conviction were imprisonment. Now, the law stands against that proposition, and the lawyer who did that obviously, had the judge sustain an objection or give a curative instruction telling the jury to disregard that comment. But the judge might have served Donald Trump's purpose at that point because he gave the pink elephant instruction. Ladies and gentlemen of the jury, I'm telling you, there is no pink elephant in the room.
Not think about a
You
pink
are
elephant.
disregard the pink elephant. If anybody suggests that the pink elephant should dictate these proceedings, blah 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 blah. So I don't think that there is anything. I don't think that there is anything outrageous about that. I think it's good advocacy. My impression is that Trump's lawyers in this case did a fantastic job. They
Well,
managed
and they're the same
not make
ones working the
about
classified
themselves.
documents case, right? I mean, these are the same lawyers working against Jack Smith in the classified documents case, and these two cases in particular, I think have raised the level of advocacy that you were really discontent with many months ago, Norm. I remember you being underwhelmed by the quality of advocacy that Trump was receiving at the beginning of many of these cases. So, at the very least, I think Todd Blanche has made a name for himself if they don't try to, go after him like a certain unnamed other attorney being, going through disbarment, et cetera, right now.
Well, we'll see. Yeah, we'll see.
Chad,
I mean, so
okay.
I mean, so
Chad
I
says, "Hey, Michael,
promised
could
to
you
take
ask?"
questions today, so here we are.
Yeah, yeah. And so, Chad, I'm going back up. Okay, so could draw an inference that Weisselberg's testimony would have been bad for the prosecution. So here it is. Here it is. Why wouldn't the judge give a missing witness instruction? Prosecution could have called / immunized Weisselberg, only other one who had knowledge of the alleged scheme and didn't. I think that there are many witnesses, Chad, that could have been called by the prosecution and were not. But I don't have the experience to answer this question even at a foundational level, Norm.
So the topic of what is and is not fair argument is obviously fodder for the appellate courts. And arguing a missing witness usually requires court permission. I don't know New York law. I know Connecticut law. And so if a party intends to argue that the state had at its disposal a witness and chose not to call that witness and wants an adverse inference, you have to get the court's permission to do so. And that's very difficult to do. Because if you're going to say, as to Weisselberg, why didn't the state call him? The response could be, well, you could have called him. But if the answer is that Weisselberg, if called, would have had to implicate himself in a crime and would have pled the fifth, therefore he's not available to the defense. He's only available to the government, which has the choice to immunize him. That is to say that we will not prosecute you for your testimony in this case. That is fundamentally unfair. But there is no provision that I am aware of, and I've tried to do this, Chad, in trials at both the state and federal level. I have tried to compel the judge to immunize a witness for the defense so that they could be compelled to testify and not claim a Fifth Amendment privilege against testifying. And the statutes simply don't give to the defense the ability to immunize witnesses. That's a power that belongs only to the government. And frankly, it's fundamentally unfair and it stinks. So I think that you can argue that it's a violation of due process. I have. I've not yet persuaded a court that I'm right. The courts give tremendous deference to the prosecution, not just in the Trump case, but in every case. So yesterday, in my murder case, for example, the murder case I'm trying, I haven't killed anybody or been accused of it yet, to my knowledge. The government granted immunity to a witness so that he would be compelled to testify. He was involved in a struggle. That struggle resulted in the death of another human being. Our claim is that death was a result of self-defense, and that the person who was testifying was one of the persons against whom our client was defending himself, and that this person could have been charged with a serious felonious assault. The government doesn't believe that. But the court held at a prior proceeding that there was sufficient reason for this man to take the Fifth Amendment. In order to get to his testimony, the government granted him immunity. And that grant of immunity says you no longer have to worry about implicating yourself, inculpating yourself with your testimony. You have what's called transactional immunity. You will no longer face criminal consequences for your testimony, and now you have to testify. There's no reason in the world why I shouldn't have that power as well, why I shouldn't have the ability to tell a court that I need a defense witness and he should be immunized. There's no reason in the world why only the government should be the one to immunize a witness whose testimony is necessary. It's just the law. And, I'm not going to defend the law. My job is to challenge it. My job is to use it on my client's behalf. My job is to advocate for changes in the law when I think it's necessary to benefit my client. I've done so and I've failed, but that is the status of the law right now.
Understood. I think you make a compelling case. I am struck by the question of by what legal standard would that be judged, and then who do we trust to even make determinations as to whether those arguments are credible, right? Because I can see that being something that defense teams would use pretty gratuitously as an argument to say, I need this witness to be immunized so that they tell the truth to the jury here.
Well, but you can chuckle because defense lawyers don't have a duty to do justice. And so would it be used gratuitously, and would it be overused, and would it potentially be abused? Yes, 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 and yes. So give the court the opportunity to determine when it's really necessary, but don't say it can never happen. Because I do believe there are occasions where the government can manipulate witnesses in such a way as to get a conviction while keeping the truth, the whole truth, and nothing but the truth from jurors. And that's simply wrong.
I guess we're going to transition into the Q&A here, but I did want to at least while we do that and while the chat kind of fills up with questions. So we're going to do a live Q&A for a few minutes here. If you've got questions, you can throw them in. We're over on Rumble, and we're here on YouTube and on X. Throw them into the chat, and I will be the great arbiter of which questions make it to our attention. However, yesterday, and while we wait on that, Vivek Ramaswamy, who I think if you've been attached to this stream at all, you know that I'm a huge supporter of Vivek. I think that his strategy, his rhetoric, His lexicon, his youth, and his intelligence are things that should be looked upon with admiration. And those young and willed and structured in a similar way should use him as a prototype for how to organize themselves politically into the future. I think he represents a prototype that should be emulated moving forward. One thing that he has done really well in his life is through entrepreneurship, building wealth through pharmaceutical companies and other things to the tune of billions of dollars. Now, there's obviously criticism to be had about how people make their money, but one thing that you can't fake is what Vivek displays every time he opens his mouth, which is competence. And so what we have learned as of yesterday is that Vivek is now the second largest Class A shareholder of BuzzFeed's publicly traded stock. So what is the current share price of BuzzFeed's Class A stock? It is currently $3 per share, if you cared to know, Norm. And that is just in the last 5 years. There's the graph. Okay, we were 5 years ago, 2021. It was trading at almost $40 a share. It fell off a cliff at the beginning of 2022, and it tried to revive itself. And here we are here at $3 a share. What it means to be the second largest shareholder isn't really anything in terms of majority control, but it does mean that he has a large say as an activist shareholder. And in publicly traded companies, I've talked about this before, activist shareholders can create all sorts of consternation internally. What he did, though, is he penned an open letter. Did you get a chance to read the letter, Norm?
I didn't. No, I'm sorry.
So I've put it on the screen, and I'll send you this link. There's a Dropbox file that he put on his X page, and he penned an open letter to the board of directors at BuzzFeed, essentially telling them that they don't know how to run a business. But he did so in a pretty constructive way, right? Gave plenty of constructive criticism. What I like about this is that it became known to me early on that he built what's called Strive Asset Management. And Strive Asset Management is a competitor to BlackRock and State Street and Vanguard and the other major institutional shareholders that work with the private banks in terms of issuing shares. And essentially what he did as an investment thesis through Strive is a rejection of the diversity, equity, inclusion, and sort of the Green New Deal, anything that was sort of pivoting away from what was historically regarded as fiduciary responsibility to shareholders and into what we call stakeholder capitalism. That is, treating uninterested parties as interested for the sake of social and cultural issues. BuzzFeed, as you know, they debuted the Steele dossier, which was totally debunked. They did all sorts of stuff to sort of crater their stock. And what he's done is take an activist role, and he's called upon BuzzFeed to actually appoint new boards of directors. He's given them a three-pronged strategy for reframing and reforming the company and building it back to profitability. And he's also pushing into their consciousness that they should actually stand for something, that they're a widely recognized brand, which they are, but they're not respected, and they failed, but that they should do something to reform themselves, make an affirmative apology to the American public for so grossly misrepresenting what journalism was supposed to be, and then use the knowledge of what's coming technologically to reform themselves. I'll say more about this in the coming weeks because I am interested to follow this. I like this because it takes the Strive asset management thesis that Vivek has articulated, and it makes it very tactical, and it puts it right in front of our faces to see how competent he is economically and from a business perspective, and why someone like him would have my vote and my support in American politics, because he appears and is the real deal. He knows what he's talking about when he talks about getting rid of the bureaucratic bloat, being able to understand how to reform certain institutions in America and in our federal executive branch. Use this as an example. If you read it, use this as an example of how to reform institutions.
Will do.
Anyway. So let's see. Q for Norm, just because Jules, we love you. How is your comedy career progressing?
It's not, Jules. I just don't have enough hours in the day to do everything I need to do. I've appeared. I've gone to comedy camp out in LA for a while. I had an invitation to go to Atlanta. The show got canceled. I've appeared in local casinos here in Connecticut and in local stand-up venues at open mics, but I'm not getting the invitations I need to monetize it. And candidly, I'm a lawyer first with 10 employees to support and a stand-up comic second. I was hoping, to do some stand-up comedy in Michigan, where I had been invited by the Michigan Criminal Defense Association to give the keynote speech in July. They had arranged a venue for me to appear at, but I got canceled as a result of my use of the N word in a failed comedic enterprise, I think in 3-4 years ago at a local venue. So the career is not progressing. I still believe that stand up comedy, is a wonderful venue, and a wonderful way to make fun of our sacred cows and get us to reconsider what's important to us. But I've just not been able to find the time to do it. So thanks for asking, Jules. Get me a gig and I'll appear. I've got plenty of material.
Well, so Saif is here. I don't know if you saw him earlier, but it says Norm does well on comedy. Product market fit is what's missing, and that's something I think that where you just have to sort of I'll use my favorite word, arbitrage it, right? So where the establishment or where the existing market doesn't exactly acknowledge something, but you believe in it, you kind of got to just force it in there, square peg, round hole kind of
Well,
thing.
I think, focusing it, a little bit of the effort here on our podcast and on live and in that direction may help. But again, how many hours in a day are there? I mean, this week I'm on a murder trial today. The murder trial is off, so I can handle a Title IX proceeding at Yale. I've got a jury picked for me in another case that I'll start the week after the murder case ends, and so the practice of law continues to occupy me on a full-time basis, and will for the foreseeable future. Whether I can fit a meaningful comedic career in there as well, I'm hoping I can, but it's tough.
Um, Bathtub Liquor over on Rumble asks, "Are there any other trials that Norm was counsel for that we can watch online?"
I don't. Yeah, I mean, they're federal trials typically do not get televised, and so state court trials do. And I'm aware of, and I recall a couple. One involved State versus Tony Moreno. This was a case where Mr. Moreno was convicted of throwing his 7-month old child off of a bridge in Connecticut. And we defended on the grounds that it wasn't an intentional act, that it was accidental. The jury rejected that defense. There were televisions in the courtroom in that proceeding. I'm not sure how much of the trial was actually televised. To be honest with you, Bathtub Liquor, I can't recall. I've tried hundreds of cases, and sometimes there are cameras in the courtroom, and sometimes there aren't. And usually within a day or two, I forget because all of the action is in the well of the court with the judge and jury. I used to be opposed to televisions in the camera on the theory that I'm such a ham, it would distract me. But realistically, it's when you're playing chess, you don't really worry what the audience is wearing. You're focused on the board. So that's my answer. I can't give a better one.
Well, certainly, I think that the Alex Jones one is one that was televised all over the place, but the procedural nature of that, it was so disparate, in my opinion, because you had the Texas-based proceedings and you had the Connecticut-based proceedings, but then he's online every day. So anyway, I just this isn't a question, but Daisy Girl in the chat says the best gig in her opinion would be the Roseanne Barr podcast, which I can't disagree at all. I think that's a really good observation. Alex,
Get me on. I'm ready to go.
Janet says Norm is used to getting chewed out by an old Jewish woman. Woo, zing. Alex Kane says, "Are Connecticut courts televised much?"
So in Connecticut, they can be televised if the press shows an interest. And so the press will have to file a petition. The court will hold a hearing. And, typically they do televise the trials. And they designate one pool camera to be present in the courtroom and require other media outlets to share the pool camera's broadcast if they care to broadcast. So, for example, in a trial that I can't talk about because of some litigation that I was involved in earlier, the Michelle Triconis case was recently televised in Connecticut, and that resulted in a conviction of Michelle for conspiracy to commit murder. My former client, Fotis Doulos, was a co-defendant in that case, but he killed himself prior to trial.
Where is 1983 litigation going, in your opinion, Norm?
To hell. 1983 litigation arises out of 42 United States Code Section 1983, part of the Ku Klux Klan Act passed in the 1870s. And the statute permitted that an individual could bring an action against an individual action for money damages against a state actor if that state actor violated their federal rights under color of law. The statute lay largely dormant until the 1860s. It was rarely used when the case of Monroe v. Pape brought it to life. Monroe v. Pape was a Chicago case against Chicago police officers who were accused of falsely arresting and illegally entering the home of a man and holding his family basically hostage while they searched the place. The courts held at that point that the Chicago police exceeded their authority and they could be sued for money damages. The courts exploded with 1983 litigation thereafter, and the heyday of 1983 litigation was in the 70s, 80s, and 90s. Longtime listeners of this show will recall our interview with John Williams. He was one of the fathers of modern 1983 litigation and was my first partner and mentor. And I spent the first 10 or 15 years of my career trying scores, if not hundreds, of 1983 cases in federal court, typically alleging unreasonable force and false arrest and denial of equal protection of the law. Many of my clients were young men of color. We got there before Black Lives Matter. The courts clamped down on 1983 litigation with a doctrine mentioned nowhere in the Constitution and really nowhere by Congress. It's a judicially created doctrine called qualified immunity. And qualified immunity gives the benefit of the doubt, gives immunity to officers in close cases. One of the comments, at least in the YouTube feed this morning when we were talking about legal standards, is don't forget arguable probable cause. How dishonest are the courts in not wanting cases against government to get to court? They've said, even if an arrest warrant lacks probable cause, as long as there's an argument that there's probable cause, we're not going to let the person who drafted the bad warrant get sued. So I think the future of 1983 litigation is grim, unless and until the Supreme Court does something about qualified immunity.
Well, certainly I asked that question. It was somewhat loaded because I can't stop thinking about things affecting the beverage alcohol industry. And I sent you this article, and I myself have not had an opportunity to make my way all the way through it, but it's not news to me. I'm just going to put it on the screen here for a moment. It is from the New York Sun reporting that the wine industry is bracing for impact of trickle-down health recommendations. What that means is that apparently the World Health Organization, which has been lobbying in Europe for a few years now to change the dietary guidelines there to say that no amount of alcohol is basically zero tolerance in terms of any sort of health benefits of alcohol should be tolerated in a balanced diet or a healthy diet. And that is now coming to the United States. And what that is going to do, certainly the wine industry has really, I don't say it's existed atop this, as part of a healthy diet, but the resveratrol claims and certain things like that certainly don't hurt it to say that, a glass of wine with dinner is good for, good for your cardiovascular health, et cetera. But I do think it's interesting because I see the production, the wholesale distribution, the retail sale, and the private consumption, even the private production of alcohol as part and parcel to our being sovereign individuals. And so as we are watching our sort of bureaucratic betters begin to constrain that, I'm interested to see where how these regulatory agencies begin to impose what I'm already seeing being imposed at the ground level in terms of criminal prosecutions of those who merely are permittees and how individual personal lives are being impacted by these sort of reverberations of a sort of a change in tone and rhythm with respect to alcohol in particular.
Well, it's an interesting debate. I mean, I see we've got some prohibitionists on our feed today. Alcohol is poison, full stop. I think we went through that in prohibition.
Chad's got a good one here. I didn't realize that Chad was about to be a bar taker. Here we go. So in my third week of bar prep, the test is at the end of July. Any horror/funny stories from those times? I'm actually somewhat enjoying the review. I haven't lost my sanity, I don't think. I've
Well,
got
I have
one.
a con
Yeah,
yeah,
go
go
ahead. You
oh,
go first. You go first.
so as regular listeners might intuit, I don't follow instructions very well, and, the result is any number of difficulties. The only time in my life I followed instructions is when I went to a Barbary bar review course. I attended every class, did every exercise, and did really well on the bar exam. Now, I graduated with honors from law school, which surprised everybody since I was rarely in no, 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 no.
Just
No, I say this because it's a funny story. When diplomas were passed out, they called me and said, "Yours is gonna be a little late." And I said, "How come?" They said, "We didn't realize you were graduating with honors." I said, "Neither did I. I was hardly ever in class." So, but I think so the bar review, the Barbary course, um, it made an honest man out of me. I mean, it follow the instructions, do the work, and the results you'll be satisfied with, and I was.
Yeah, make it made an honest man out of you. I think that's a great way to put it. I would share the same. Mine was a bit of a horror story, but I think in retrospect it supports what you just said about making an honest man of you. I did the Barbary course, and we had a regimented study scheduled that summer, and I was particularly nervous about, and very apprehensive about taking the bar. For a number of reasons, but just in general. And I recall about 2.5 weeks from the date of the exam, we went to an office that, a family friend had a business, and they didn't use their conference room very often. So basically dedicated to that during the day so that we could get out of the house. There's three of us that studied together, and we were doing our some morning work that we did together. And like I said, everything was regimented in terms of what doctrinal course we were looking at, what types of questions, how we were engaging in either individual or as a group. And we always did a few sort of fact patterns and then lob sort of issue spotting, essay answers kind of thing in mid morning. And we were going through that. And I think that I had reached a limit. I don't know if you experienced this, Norm, during your bar prep. I had reached this limit and was fatigued, emotionally, spiritually, physically. And my answer didn't at all mirror or match up with the answer of the other two. And I had almost an out of body experience. I remember not saying a word, just getting up from the conference table and walking out of the conference room. And my legs kept moving. I walked out of the office. My legs kept moving. I walked out of the parking lot. My legs kept moving. And I started walking down the train tracks that were right next to this office. And I got about a quarter mile down the train track. And it wasn't a very, I wasn't in danger, and I wasn't trying to put myself in danger. I'm not admitting to anything here, but it took about maybe 10 minutes really of straight walking before I came to. And I was sitting there, like, just on the side of the train tracks there. And I remember calling my mother, and she picked up. And I don't really call my mother that often. Sorry, mom. And so she was startled just because I don't call that often. That's just in my nature. And so I just started apologizing profusely for, being a failure, right? For disappointing her and all that kind of stuff. And of course, she was just, flowering me with compliments and trying to build me back up and blah, blah, blah. And I'm grateful for that moment. I eventually, walked back. I took the rest of the day off. Really had a total break. I took the rest of the day off, and then started up the next day and did swimmingly. All of a sudden, after that break, something happened mentally where the multiple choice troubles that I was having almost cured. By the end of it, I was hitting 100% on all the multiple choice stuff. Walked into the bar exam and felt like it was one of the easiest exams, even though I was putting pressure on myself. One of the easiest exams I'd ever taken in my life. So, to
So,
your
Chad,
point,
here
Norm,
yeah, go ahead, go
to your
ahead.
point, Norm, about making an honest man of you, I do think that there are times in your life, and the bar exam prep was one of those for me, that mirrored a lot of my formative years playing athletics, right? And education and academics can be the same. You're going to get out what you put in, and the rigor that you really subject yourself to is going to yield results.
And Chad, just as a word of advice, don't. This is not a critique of what Mike just said, but don't put too much pressure on yourself with respect to the bar exam. You're likely to pass, and if you fail, take it again. But all the bar exam does is it assures the public that a person who passed it is minimally competent to recognize a problem that walks into their office. The law talks in terms of fact patterns. You'll recognize what a contract is, what a tort is, what potential solutions there are to problems, so that when a client walks into your office and says, I just shot my landlady, you don't say, oh, that's a breach of contract case. I mean, it's just an orientation toward a very complex set of rules that govern civil society. Don't put too much pressure on yourself. Make sure you get it right. Hey, here's a call out. Nick Ricida is apparently having some difficulties. I've been asked to give him a call, and I haven't heard from him. Anybody in touch with Nick, get him in touch with us. Nick, I'm not sure what's going on. Apparently there was an arrest,
yeah, I know some details. Friday on Laid Back Law. Our group of law tubers are connected, so I think you and I can talk offline about that, Norm. One
so
last thing.
Shout out to Nick Ricida, though. Get in touch with us, Nick. We love you, and we're here to help you.
One last thing, or at least one last comment from my side over on Rumble. And Lawyer Will says you definitely don't need to take the in-person Barbary course. Just get the books and study the Barbary books. Include a study.
Yeah, that's you, Lawyer Will, because you're organized. I need somebody there with a whip and a chain to say, study.
Christy asked, Norm, have you ever heard of a C curve in law school? And I love this question. You want to take it?
No, because when I was in law school, I just didn't pay any attention to grades. I didn't pay any attention to anything other than what I was reading. And when I went to class, I was a pain in the ass. I went to law school later in life, and I just didn't think there was anything that anyone could tell me that I couldn't figure out for myself. And so although I graduated with honors, I didn't really graduate that well. And it's a miracle that I got out of law school. So C curve, no. Mike?
Oh, I totally understand what it is, because law school is all graded on a curve, meaning that you don't really get what you get numerically as you might be used to in any other setting. Law school grades to force a C average of all the cumulative grades in the class, meaning that if there are 10 of you and 5 of you get a 70 and 2 of you get an 80 and 1 of you gets a 90 and 1 of you gets whatever, most of you who got a 70 are going to get a C, regardless of whatever that would have been numerically or from a grading rubric. Or even if 5 of you got an 85 or 5 of you or 6 of you got a 90, you're still probably going to get a C, because that's what the standard bell curve does. It forces most of the average in the middle to be that meaty part of the classroom. The reason I'm so aware of that, Norm, is because I was given a merit scholarship to go to law school. Part of maintaining the merit scholarship was maintaining a 3.0 GPA or higher. And then once you realize that you're put into a class of all the other merit scholarship recipients, and that the class is graded on a curve, things get really, really dicey really quick.
All right. Well, good.
And I maintained it the whole time.
Customer states Pacific Northwest. The arrest warrant is damning. Pray for the kids and Nick and Kayla. Janet Smith reports that Viva Fry is all over it for Nick. Let's find Nick. Let's give him our support. Let's give him our love. Sounds like he needs it.
Well, Norm, this was good. A little bit underwhelmed by the questions, but I think, Chad, you kind of saved it with the law school stuff. So thank you for that.
Wow. Blue Raptor, do you like anyone? Don't answer that question. Listen, folks, thanks for listening to Law and Legitimacy. Where do people find us?
Right here at Law Pod Daily. Many of you are coming to us right now from X. That's at Law Pod Daily. Many of you are coming to us by way of YouTube. That's at Law Pod Daily. And if you're over on Rumble, we are at Law and Legitimacy. I still haven't figured out how to have our channel name changed. So if anybody actually has anybody over at Rumble that would just talk to a guy about trying to use whatever tools they have a little more effectively. I don't really spend my life liking to bitch about things, but Rumble just makes it a little bit easier for me. Anyway, that's where you find us. You can also find the audio-only versions of these streams every day, uploaded right after the stream on Apple Podcasts, Spotify, Google Play, Overcast, Audible, wherever you find podcasts. And certainly now is probably a better time than ever to go and subscribe to the audio-only versions of the podcast, since Norm is sounding like, I don't know, a baritone saxophone. It's awesome.
Of course, that's not what a baritone saxophone sounds like. AMF Yo-Yo, I'm on my way to prepare for a hearing with the Yale University-wide Committee on Sexual Misconduct, a confidential hearing, I might note, so I can't say more. We'll talk to you tomorrow morning at 8 a.m. Be well, everyone. Peace out.
See you later, Norm. Bye, everybody. AMF, yo-yo.